Imagine hearing the words that you are under arrest. And in that moment, your mind is racing, your heart is pounding, and panic sets in. What do? Do you answer every question or stay silent? Can you call your lawyer, your friends, or your family? Can the police even arrest you without a warrant or without telling you why? I'm sure these are few questions that would immediately pop up in your mind if you are being arrested. And most people would either be clueless or confused. Being under arrest doesn't mean that you've lost all your rights. In fact, some of the most important ones arise at that very moment. And in this video, I'll walk you through exactly what some of those rights are. But before we dive in, one thought that needs to sit at the back of your mind throughout this entire video is that arrest is supposed to be the exception, not the reflex. Meaning that the power to arrest you is not the same as the necessity to arrest you. The police doesn't get to arrest first and then think later, because every arrest and every hour after it has to be justified. Keep that in mind. And one distinction that you need to be clear about is the difference between custody and arrest. See, custody is a broader concept. It's a situation where you're under police control or supervision, but not formally arrested. But the moment you're no longer free to leave, that is arrest in substance. And it triggers every safeguard that comes with it, regardless of what police chooses to call it. Now back to the situation. You've just been informed that you are under arrest. Now what? Number one, try not to panic. I know it's easier said than done, but try not to panic. If you do, you'll certainly forget what you learn in today's video. Try to stay calm and don't try to over-explain yourself. Even if you sound completely convincing that you've done nothing wrong, that won't get you released on the spot. Because understand this, the decision to arrest you has already been made, and you cannot physically resist arrest or run away. You're going into police custody, accept the fact and try to remain calm. Now, the first question you'll probably ask the police officer is, why am I being arrested? Right? And you'll want to hear an explanation of what you've done. But before that, you yourself need to know in what situations can you be arrested. It's a long list and quite difficult to make an exhaustive one, but let's go through some situations where you can be under arrest. Number one, you could be arrested without a warrant if you've committed a cognizable offense in presence of a police officer. Now, what is a cognizable offense? See, every offense under the Bharatiya Nyaya Sanhita, which was earlier referred to as the Indian Penal Code, is classified as a cognizable or a non-cognizable offense under the first schedule of the Bharatiya Nagrik Suraksha Sanhita, earlier referred to as the Code of Criminal Procedure. In simple terms, a cognizable offense is a category of offense for which a police officer can arrest you on the spot without a warrant. Number two, you can be arrested if a reasonable complaint has been made against you, or credible information is received, or maybe a reasonable suspicion exists that you've committed a cognizable offense punishable up to 7 years. And the police officer is satisfied that A, you've committed the offense, and B, that your arrest is necessary either to prevent you from committing any further offenses or for proper investigation, or to prevent you from tampering with evidence, or to prevent you from inducing or threatening any person acquainted with the facts of the case, or maybe because your presence before the court cannot otherwise be ensured. Number three, you can be arrested if credible information has been received that you've committed a cognizable offense punishable with more than 7 years, and the police officer arresting you has reason to believe that you've committed it. Number four, you can be arrested if you fail to comply with the notice of appearance sent by the police. If they call you to the police station and you fail to go, you can be arrested. Number five, you can be arrested on the spot if you've been found with any stolen property or a banned or illegal substance. Number six, you can be arrested if you obstruct a police officer in execution of their duty or try to escape from lawful custody. Number seven, you can be arrested if you fail to appear in court despite being summoned and the court issues a non-bailable warrant against you. Number eight, you can also be placed under preventive arrest, meaning where a suspicion exists that you may commit a cognizable offense and the police believes it cannot otherwise be prevented. As I said, it's not possible to make an exhaustive list, but I hope by now you have a broad understanding of some of the situations where you can be arrested. Now let's dive into what you should do. Number one, calmly ask the police officer arresting you, why am I being arrested? What are the grounds of arrest? And demand them in writing. Because see, the police officer making your arrest is obligated to inform you of the grounds of arrest. And this isn't a mere procedural formality. It flows from your fundamental right of personal liberty. You must be informed of the grounds in writing and in a language that you actually understand. Mere reading of the grounds aloud isn't allowed because you may not be in a state of mind to retain what was said, which is precisely why a written copy is necessary. Now, where does this right come from? Article 22(1) of the Constitution of India states, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest. This constitutional mandate is also effectuated by Section 47 of the BNSS, which states, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds of such arrest. Now you're probably wondering that the Constitution and the BNSS use the word as soon as may be and forthwith. What does that practically mean? Does it mean that the grounds of arrest have to be informed to you immediately or within 10 minutes or once you reach the station or before you've actually been taken into custody? We need to understand that there has to be a judicious balance between safeguarding the arrestee's constitutional rights and preserving the operational continuity of criminal investigation. And whenever the interpretation of law can have multiple outcomes, we follow the interpretation by the courts. Let's see how the court has interpreted as soon as may be. The Supreme Court in Mihir Rajesh Shah versus State of Maharashtra and another, citation 2026 1 SCC 500, has held. Article 22 says as soon as may be, which would obviously mean not prior to arrest, but can be on arrest or thereafter. The indication is as early as it can be conveyed. There may be situations wherein it may not be practically possible to supply such grounds of arrest to the arrested person at the time of his arrest or immediately. It may not be possible for the officer to provide the grounds of arrest in writing before the arrest or forthwith on the arrest to the accused. A rigid insistence upon informing of written grounds may result in the police officer not being able to discharge their duty and responsibility efficiently and effectively. A balance between compliance of the constitutional as well as the statutory mandated safeguard on one hand, vis-a-vis the effective discharge of lawful statutory law enforcement duties and responsibilities cast upon the state agencies must be struck. Where informing the grounds of arrest in writing on arrest is rendered impractical, it shall be sufficient for the police officer or other person making the arrest to orally convey the same to the person at the time of arrest. Later, a written copy of the grounds of arrest must be supplied to the arrested person within a reasonable time and in no event later than 2 hours prior to production of the arrestee before the magistrate for remand proceedings. This period would ensure that the counsel has adequate time to scrutinize the basis of arrest and to gather relevant material to defend the arrestee proficiently and capably while opposing remand. The 2-hour threshold before production of the remand thus strikes a judicial balance between safeguarding the arrestee's constitutional rights under Article 22(1) and preserving the operational continuity of criminal investigations. Now, what does this mean? As an accused, you need the grounds of arrest in hand before you're produced before a magistrate so that you can actually defend yourself, oppose police or judicial custody, and press for bail. This stems from the basic principle that a person facing accusations must be given a real opportunity to defend themselves against those accusations. Number 2, ask if the offense you're being arrested for is bailable, because under section 47(2) of the BNSS, where a police officer arrests without warrant any person other than a person accused of a non-bailable offense, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. So once you know the grounds and reason of arrest, you'll know if the offense is bailable or non-bailable as per the first schedule of the BNSS, and you can take necessary steps to be released on bail. Number 3, immediately inform someone that you have been arrested. Under section 48 of the BNSS, every police officer or other person making any arrest under the Sanhita shall forthwith give information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other persons as may be disclosed or nominated by the arrested person. So the timeline is pretty clear. The officer must inform you of this right as soon as you're brought into the police station. And this becomes really important. In case no one knows that you've been arrested, who would take the steps to get you out? Hence, this is a mandatory requirement to be fulfilled. And the law places a duty upon the magistrate before whom you are actually produced to satisfy that this requirement has been complied with. So by now, you have been arrested, informed of the grounds, and information regarding your arrest has been shared with your relatives and friends. What next? Number 4. Procure a copy of the FIR as soon as possible. Under the BNSS framework, the FIR becomes part of bundle of documents that is supplied to the accused once the police report is filed before the magistrate. However, that stage comes later, much later after your arrest. It is absolutely crucial that a copy of the FIR is made available to you, your family, or your lawyer as soon as possible. Because when someone is arrested, the natural instinct is to wait. Wait for the police to explain things, wait for the court date, or wait for your lawyer to handle it. But one document you must procure immediately is the FIR. Why the rush? Because opposing remand or arguing your bail without having read the FIR is like fighting blindfolded. Although an FIR isn't supposed to be an encyclopedia enlisting every minute detail of the offense, however, the essential ingredients have to be made out and mentioned in the FIR. Think about it. How do you argue against an accusation you haven't seen in writing? Now, if you are under arrest, how do you get a copy of the FIR as soon as possible? The Supreme Court in Youth Bar Association of India versus Union of India and another has issued directions pertaining to the right of an accused to get copy of the FIR before the stage of magistrate providing a copy. In this judgment, the court has directed that an FIR must be uploaded on the police or state government's website within 24 hours of registration. However, this direction does not apply to FIRs registered in sensitive matters like sexual offences or offences under the POCSO Act. So how do you get a copy of the FIR as soon as possible? Unless it's a sensitive case, you or your relatives can go to the concerned police department's website, enter the details like FIR number and police station, and download a PDF copy of the FIR. In cases where the FIR is not uploaded online, your representative can procure a certified copy by making an application for it. But remember this, the earlier you have a copy of the FIR, the more time your lawyer will have to prepare. Number 5, your right to meet your lawyer. Don't get me wrong, but it's not exactly like they show it in the movies or shows, that your lawyer walks in, saves you, and takes you home. Let me explain what your rights are and what limitations apply. Article 22(1) of the Constitution of India, right after the grounds of arrest guarantee, states, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now, this constitutional right is also effectuated under Section 38 of the BNSS, which states, where any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout the interrogation. Now let's break this down. Does this mean that your lawyer sits with you throughout the interrogation or remains present for the entire duration of your custody, helping you answer every question? The answer is no. Your lawyer's involvement at this stage is minimal. Yes, you have a right to consult them and to have a confidential communication, and the police cannot convert this right into an empty ritual by denying access or by reducing it into a meaningless encounter. The police, however, is not required to wait indefinitely for your lawyer to arrive before beginning or continue interrogation. This is not an absolute right in the sense of requiring a lawyer's physical presence before any question can start. You cannot insist as a right that your interrogation cannot begin until your lawyer is physically present. There is a clear distinction between consultation, right to counsel, and a blanket right to a lawyer-assisted interrogation. The constitutional right is one of meaningful access to counsel, not a veto over police questioning. So the lawyer's presence is limited and the police need not pause investigation until the lawyer appears. It's a key safeguard that the accused should not be denied a reasonable opportunity to consult his lawyer. Here's what it actually means. Your advocate can be present, your advocate can observe, and courts have described this as a watching distance, meaning visible but not necessarily within the hearing range of every exchange. Basically, your lawyer cannot run the interrogation for you. Number 6, your right to remain silent and against self-incrimination. You must have heard or seen this play out in the movies and shows. When a police officer making an arrest gives out these warnings aloud. You have a right to remain silent, but anything you say can and will be used against you in court. You have the right to attorney, and if you cannot pay for a lawyer, one will be provided for you. See, these are called the Miranda rights, which the police in the US must give suspects before questioning them. Indian law, however, does not require Miranda style warnings because statutory protections already operate. Now, while you're being questioned, two critical protections apply: your right to remain silent and your right against self incrimination. And these are constitutionally anchored in Article 23, which states, no person accused of any offense shall be compelled to be a witness against himself. This is also coextensive with section 180 of the BNSS, which states, such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than questions the answer to which would have a tendency to expose him to criminal charge or to a penalty or forfeiture. So basically, you cannot be forced to confess. Even for some reason, maybe psychological pressure, you answer or confess to something which incriminates you before a police officer, that confession will not be admissible in court. Section 23 of the Bharatiya Sakshya Adhiniyam, earlier referred to as the Indian Evidence Act, protects your right against such forceful confession. It states, no confession made by any person while he is in the custody of a police officer, unless it is made in immediate presence of a magistrate, shall be proved against him. There is although a narrow exception to this. If any statement made by you or portion of it directly leads to any discovery, that portion of your statement would be admissible. For example, if someone confesses that he robbed a bank and hid the money under a tree somewhere, and that statement leads to the actual discovery of the money, that would be admissible. Key takeaway here is, while you're being interrogated, you cannot be forced to be a witness against yourself, and confessions made to the police are simply not admissible in court. So can you stay silent? Yes, you can. During police interrogation, your silence cannot be treated as an admission of guilt because the state has to prove its case independently. But at trial, if the case is built around circumstantial evidence and you've asked to explain facts specifically within your knowledge and you offer no explanation at all, a court can draw an adverse inference at that later stage. This is a completely different stage from police interrogation, and the two should never be confused. I'll cover this in another video later. But you need to remember the exact boundary of this protection. It covers testimonial acts and not physical evidence. Number 7, your right to a medical examination. So there are actually 3 different medical examinations serving 2 very different purposes. 2 of them can actually produce evidence and be used against you, and the other one is meant to protect you. Section 51, 52 and 53 of the BNSS provide for medical examinations of person arrested. Section 51 is a general provision. However, Section 52 specifically relates to medical examinations of an individual accused of rape. Now, these provisions talk about scenarios where there are reasonable grounds of believing that your examination can afford evidence as to the commission of an offense. And in this scenario, it shall be lawful on the request of a police officer for a medical practitioner to make such examination and even to use force as reasonably necessary for that purpose. Now, these examinations can include examinations of your blood, swab, sweat, hair samples, fingernail clippings, and so on. The purpose of these examinations is to collect and preserve evidence that can afford evidence as to the commission of offense. For example, if you've been accused and arrested for culpable homicide using a weapon, and that weapon is discovered and covered in blood, your blood can be collected to match the sample, to afford evidence as to the commission of the offense. The other medical examination mandatorily conducted of every arrested person is under Section 53, and its purpose is to record any injuries or marks of violence upon the person arrested, along with the approximate time when such injuries or marks were inflicted. And this report has to be provided to the arrested person or a person nominated by him. This examination is very crucial as it generates a record of any or all injuries that may have been inflicted upon you while you're brought into police custody. It also acts as a protection against any illegal interrogation techniques or physical violence that may be inflicted. It also acts as your own evidence. For example, if you've been arrested for physical assault, but the intent of such assault was your own self-defense, in such cases, your medical examination report will be an essential piece of evidence showing the injuries sustained by you leading to your action of self-defense. And you don't have to demand this right. This is a mandatory duty of the state. And if you're a woman, any medical examination has to be conducted by or under the supervision of a female medical officer. One more thing, there is also an ongoing duty of whoever has custody of you to take reasonable care of your health and safety throughout the period of your detention. And under the Supreme Court guidelines, your examination should be repeated roughly every 48 hours if you remain in custody. Number 8, your right to be produced before the nearest magistrate within a period of 24 hours. Article 22 of the Constitution of India states, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of the arrest to the court of the magistrate. And no such person shall be detained in custody beyond the said period without the authority of the magistrate. This is also given effect through section 58 of the BNSS. So the clock starts the moment you are physically restrained, the moment you're no longer free to walk away, regardless of when the paperwork was filled out. This is often called as the de facto arrest principle. This arrest and production safeguard is mandatory, not discretionary. The police must produce you before the magistrate within the prescribed period, and the magistrate's power to remand is triggered only after your production. Until then, the police custody is the only initial custody incidental to arrest. Now, why is this important? It's because this isn't a mechanical production. This is a stage where the magistrate decides if your further custody is legally justified or not. And your application for bail or opposing police remand can also be argued at this stage. Now, let's talk about the remand hearing, the hearing that takes place once you've been produced before the nearest magistrate. And this brings us to right number 9, your right to be heard. This is the stage where your liberty is actually decided, and it's not and should never be treated as a formality. Now, what does remand hearing actually mean? It's basically the court deciding where you'll be held while the investigation or trial continues. And the magistrate has to independently examine and check that the arrest itself was legal and that every constitutional safeguard was actually followed. And after this hearing, two kinds of custodies can be ordered. Number 1, police custody, which is capped at 15 days from the date of arrest for further investigation, or judicial custody, meaning actual jail, which can be renewed periodically. At this hearing, you have the right to oppose your remand through your lawyer, argue against police custody, or for release outright. You have a right to be heard at this stage, and your bail can even be considered without a formal application. And you cannot be denied this hearing just because you were produced after court hours or maybe on a holiday. You have to be heard regardless. And after this remand hearing, you will either be sent back to police custody or judicial custody or be released on bail. Now, what if none of these rights were followed, or what if any of these rights were ignored? If the police kept you in custody for more than 24 hours without producing you before a magistrate, or if any of the legal safeguards we've just discussed were ignored, you have effective remedies under the law. You can challenge the legality of your arrest and your continued detention. If the case is bailable, you should apply for bail immediately and be ready to furnish the required bail bond. Even in non-bailable cases, procedural violations can strengthen your case for bail. I'll be making a separate video explaining the law of bail in detail, so keep an eye out for that. See, at the end of the day, the power to arrest is one of the strongest powers the state has, but it's not unlimited. The law places checks on that power at every stage, from the moment you're arrested until your custody is reviewed by the court. Knowing these rights can make a big difference. If you'd like to understand these rights in greater detail, I've also published an article on our website. You'll find the link for that in the description below. If you found this video helpful, please hit the like button and share it with your friends and family. Because the more people who know their legal rights, the stronger those rights become in practice. And don't forget to subscribe if you'd like to see more such informative legal content. Thanks for watching, and I'll see you in the next video.